We're back, News Talk 107.9 FM, Viewpoint Show with Dan Morris on a Tuesday. 272-9228, 1-800-289-9228. My in-studio guest as we lead off the week is James Anderson, attorney at law, trial attorney, ran for Attorney General as a Democrat. Not going to hold that against him. Today's his birthday. Not going to hold that against him either. Talking about the case, and we're looking at weekend review, so we can look at a preview of the week. Again, and going back, that standard, what that judge says, the instructions that they give to the jury is going to be critical, I think, for this case. What is the limitation that Judge Thompson's going to have on giving the instructions when he says he's going to have to define what a bribe is, for example? Where is he going to go to get that, and how much involvement would the prosecution and defense have on that?
Well, the prosecution and the defense will make proposed jury charges to Judge Thompson.
Mm-hmm.
And Judge Thompson can do whatever he wants to with it.
He can say, you're crazy, or I'm going to find this, take this out. Will that have anything to do if he doesn't follow it with any kind of mistrial?
Well, it could. If the judge instructs the jury on something that is improper,
mm-hmm.
if he says, I'm here to tell you what the law is.
Yeah. I'm going to define it as this, and if someone else doesn't.
If he makes what he thinks is the definition of this type of bribe, that could be something that would be something that either side could appeal.
Mm-hmm.
And said the standard that you gave was too great, too small.
But where will he come up with the standard for the charge to the jury? Where will he come up with what the definition of a bribe
well,
is?
There's been some standard charges that have been accepted criminally, federal
mm-hmm.
criminal in charges, but there's also case law. Off there, we were talking about the Scrushy case.
Mm-hmm.
That allegation was a bribe there, that Scrushy gave $500,000 to a particular campaign, and that Siegelman then put Scrushy on this certificate of need board. There's some language that the 11th Circuit, which is the circuit that's over the Montgomery
mm-hmm.
District Court, that's headquartered out of Atlanta, they said in that case about you don't have to have it out there in black and white. You don't have to have a photograph of it, because the nature of the beast, so to speak, is something where you can't ignore nods and winks.
Right, and we see $500,000 being contributed, and we see getting on the board, and someone says this is what the arrangement was, and we see the facts of it, and so boom, you're guilty.
And that's some of the stuff that this FBI agent that's been testifying, that's on the stand
mm-hmm.
even as we speak, I think now, he's been saying, well, that means he was offering this, and the defense has been, oh no, you misunderstood.
Right. You
got this wrong. So the defense with this FBI agent has been trying to say, look, you're a good guy, you're doing your job, but you only knew one side, and you didn't see the whole spectrum about, as Paul Harvey used to say, the rest of the story.
Let's go to the phones here and go to our caller here. Let's see what he's going to do. Yes, it's the one and only Big